Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Karnataka High Court. Friends, in the classes I told you about the forum shopping. CPC వాళ్ళకి చెప్పాను forum shopping. Simply to say, మనం ఒక కేసు వేయాలి హైకోర్టులో అని చెప్పి లాయర్ గారి దగ్గరికి మీరు వెళ్తారు. వెళ్ళినప్పుడు లాయర్ గారు 2 నెలలు ఆగేద్దాం లేరా, జడ్జి గారు ఈ బెంచ్ కొంచెం మనకి ఫేవర్ కాదు, నెక్స్ట్ టైం చేయమని ఎలా చెప్తుంటాడు. That means you can get things done through the forum you like. That is forum shopping. Here, Justice Nagaprasanna of Karnataka High Court, he found the judicial hide-and-seek game played by 5 people. So, he has slapped 10 lakhs cash, 10 lakhs exemplary costs on the litigants for suppressing the fact in the litigation and filed it 9 times. Cause of action మార్చారు. Of course, with the same cause of action, facts మార్చారు. చూడండి ఎంత తెలియగలడు. 9 times. He opined that, please remember, imposition of such heavy cost was necessitated as it is a 9th petition on the same cause of action. So read the case law. Case law is Srimati Gangammavva&ors versus State of Karnataka and others. Yesterday, he has given the exemplary, awarded the exemplary cost. When I go to the root of the case, this is a land acquisition matter. Land acquisition matter. 5 litigants. Who are the LRs? Original ones చనిపోయారులేండి. 5 litigants. They challenged the land acquisition case. Actually, the case which started in the year 1986. And they have been successful. Of course, they were not being successful even though they tried for 8 times, and this is the 9th time, which was identified by, which was found by, which was traced by, which was noticed by the High Court Justice M.Nagaprasanna. They suppressed the fact. Even though they filed the matter 8 times, they failed all the times in the same matter. Right. So, in the year 1960, the litigation began. 2 acres and 20 cents of land was registered. It is the registered land in the name of late Venkata Bhovi alias Dasappa and late Hanumanta Bhovi, Venkat Bhovi and Hanumanta Bhovi. Actually, this was registered in these 2 names in the year 1979. But of course, the litigation started in the 1986. 86 లో ఏమైందంటే the state government wanted to alienate the land to go for housing, to go for a cooperative colony, cooperative housing colony. Therefore, they issued notification D and DD section 6 of the Land Acquisition Act 1984. ఇప్పుడంటే పేరు మారింది కాబట్టి 2013 యాక్ట్లో, అంతకుముందు Land Acquisition Act 1986. So collector has to give the notification. He has given D and DD declaration కూడా అయిపోయింది. ఎందుకని purpose is to assign the land to the cooperative society for the development of a residential area, housing colony, urban housing colony. Definitely, it is very, very essential to develop for a city. Right. So ultimately, 1986, the final notification was given in the year 1997. Right. Of them, 2 landowners, they were paid compensation also. But after their death, their legal heirs, in the year 1993, they started the litigation. 1993, the legal heirs. Right? In 1994, with the other sides, Vishitra, cooperative society people, they approached the High Court with the plea of delay by the state. వీళ్ళు కోర్టుకు వెళ్ళారు, ఆటోమేటిక్గా లేట్ అవుతుంది కదా, వాళ్ళు హైకోర్టులో వేశారు, అయ్యా ఈ లిటిగేషన్ పెట్టి లేట్ చేస్తున్నారంటే ద హైకోర్ట్ సెడ్ హ్యాండ్ ఓవర్. ఎందుకంటే మ్యాటర్ ఈజ్ వెరీ క్లియర్, రికార్డెడ్గా తీసుకున్నారు, ఎలైనేటెడ్ ద ల్యాండ్. దెన్ యాజ్ రిగార్డ్ ద కంపెన్సేషన్, సో ఇట్ ఈస్ ఎ డిస్ప్యూట్. కంపెన్సేషన్ పెంచుతారు తగ్గిస్తారు, అది సివిల్ కోర్ట్ వ్యవహారం, కలెక్టర్ వరకు అయిపోయింది. నౌ ద మ్యాటర్ హ్యాస్ కమ్ టు ద సివిల్ కోర్ట్. సో కాబట్టి హ్యాండ్ ఓవర్ ద ల్యాండ్ ఫస్ట్ అని చెప్పి హైకోర్ట్ హ్యాస్ గివెన్ ఎ డైరెక్షన్. అందుకే మీకు చెబుతుంటాను, ఎమినెంట్ డొమైన్ So the state has got every authority to alienate, to acquire, to assign a land. You have to fight only for the compensation, that's all. So handover. So government has to hand over, but the litigation continued. In the year 1997, 2003, 2004, 2007, 2012, 2016, ultimately in 2024. They approached all the civil courts and high court. In all these cases, to their bad luck, the LRs failed. Right? Ultimately, in January 2024, January 2025, a writ petition was filed by the LRs. So before the Honorable Justice M.Nagaprasanna, in which it was highlighted that in 1993, there was a recommendation to drop from the Land Acquisition Act. Of course, the political law, land acquisition matter law, the concerned minister, we can give to orders. Political opinion, but anyway, High Court order hand over chestamata vastavam. Right. Now the High Court is of opinion that these litigants, they are resorting to the game of hide and seek, judicial game of hide and seek. సో ఫ్యాక్ట్ చెప్పకపోవటం. అందుకనే మీకు ఒక పొలిటీషియన్ కేసులో కూడా చెప్పాను, నార్మల్లీ లాయర్స్ తక్కువ వాళ్ళు చేస్తూ ఉంటారు, కానీ దీనికి చేయడానికి ఏంటంటే వెనెవర్ యూ ఫైల్ ఏ petition for anticipatory bail or bail, you have to mention that no other such application is pending in any other court అన్నమాట రాయాలి. అలాగే ఇక్కడ కూడా no litigation of this type is pending in any other court అని కూడా రాయాలి. You have suppressed the fact. So now, if this type of petition is entertained at this stage on any score, it would amount to putting on the litigative persistence of the plaintiffs seeking same prayer. దీన్ని ఇలా కంటిన్యూ చేస్తే చాలా ఇదవుతుంది. సో awarded 10 lakhs to be paid to Karnataka State Legal Service Authority within 4 weeks. Right? So any litigant, ఇది కాస్ట్ అన్నమాట, నోట్, హైకోర్టు మళ్ళీ నోట్ ఇచ్చింది. ఎనీ లిటిగెంట్ who dares to sully the sanctity of the judicial proceedings through deceit, misrepresentation, fraud, definitely the court will think that he is committing assault on the judiciary, on the majesty of the justice. And court will think that it is a direct assault on the edifice of the judicial integrity. It will not be tolerated. This is what the Honorable High Court wants to impress upon, wants to stress upon, wants the public to know. Because in the topic of res judicata, one case and one judgment are enough to decide a case. If you want to prolong the cases in some other form, so there is no end to the litigation. The litigation will be continuous. We have to put an end. So therefore, Honorable High Court has put an end by imposing exemplary cost on the litigants of 10 lakhs. జనరల్గా 1,000-2,000 వేస్తారు, 10 లక్షలు వేశారు. So read the case law and analyze your legal law. Thank you.